Kimoto has finished.
We are most obliged. We'll share 1 minute each with Mr. Mari. Thank you.
Yes, sir.
People are yet to come, including the respondents. I hope you take note of that. There's no need for repetition, absolutely none.
Yes, sir. The reason why we are in support of the conservatory orders remaining in force is that when Justice Richard Mwongo was issuing these orders before Kirugoya Law Courts, he had in mind petition E013 and petition E014. So he knew very well what he was doing because we appeared before him several times and we tried to stop the impeachment proceedings. However, it was not possible and he consolidated the files. Therefore, if you look at our petition E013, what we are asking for is an apology by the Deputy President of Kenya, Honorable Rigathi Gachagua. So if these conservatory orders are lifted, what are we going to do? Are we not engaging in an academic exercise where our petition has been consolidated, but we are not being given a right to fair hearing so that the court can understand why we need this apology? And this petition was filed first. It was filed on the 25th September before the impeachment and after the impeachment. So we are praying that we be given a right to fair hearing. We be heard first. We have nothing against Professor Kindiki. However, once he assumes office, he will now become a deputy president, and therefore we do not need an apology from Kindiki. We need an apology from Rigathi Gachagua. And we need an apology from him when he's at his official residence. No. They will have, no, allow me to.
My Lord, may I just interfere? The petition by Kimoto and company required the Deputy President, then, now impeached, to apologize to the National Intelligence Service, NIS, completely overtaken by events. I don't even know why she's here.
No. That is uncalled for, and I hope the bench will protect me.
I think Ms. Kimoto is rightly before the court.
Yes, thank you. Thank you, Judge, for protecting me, because I almost quoted the paragraph 110 of the disposition of this court where you assured us that we are going to have a fair hearing. So therefore, thank you, Justice Charo. So what I'm saying is that, yes, so what I'm saying is that we need an apology from the Honorable Rigathi Gachagua, him being the Deputy President of Kenya. So what we are saying is that we want him, at least we are going to support even the issues of how he was impeached so that we can get to the bottom of this. And we still have a chance because he has not left office. And if he has not left office, then we have a chance to be heard in our petition, E013. So allow us to be heard so that after we are heard, the court can decide if our petition has merit or not. And that's why we are in support of this. And we do not want a kienyeji apology. Our apology is very clear from our pleadings, because these utterances he made when he was in office, and they carried weight. Why we are insisting is that the NIS team, and especially my client who is affiliated to the NIS, he was affected. In fact, where he stays in Kirinyaga, he cannot stay anymore because of those utterances. No, these issues are in our petition. The respondents have not responded. In fact, our petition is unopposed. So therefore, we are insisting, if at the interim stage, the conservatory orders are lifted, what it means is that we will not have a chance to get what we are praying for in the final stage. So it will be in our view, we will have been overtaken by events at that particular moment. Therefore, when we remove this conservatory order, it only means that we'll have a final order in the interim, because now there will be a new deputy president, and we sued Honorable Rigathi Gachagua when he was the sitting deputy president, as deputy president, not as Honorable Rigathi Gachagua. So we are praying that the court do look at this. There was also an issue of public participation. Once we were consolidated, those are the issues that are also in petition E014 on how the public participation was conducted, which we, of course, we support. It was hurriedly done. So we did not even have a chance, or many people and many Kenyans did not have a chance to give their views. So again, just 1 minute. Again, this is what we are saying. It will now go to an academic exercise where we just appear before the court and expect just to be told you have no right anymore, and you're overtaken by events, just like some councils were trying to say. That's all. Thank you.
Thank you.
Your Lordship, for the third petitioner.
Sorry, my lord, I was to take cue. My name is Sam Nyaberi. You gave indications and directions earlier that we take 2 minutes. I wish to call upon Waithera, who was on her feet before, so that I donate my time to her in the spirit of nurturing young talent, and so that she can also raise a fee note to be paid.
Ms. Waithera, how are you?
I'm fine, thank you, my lord.
You have been donated time, so take it and make your submissions.
Thank you, my senior Mr. Nyaberi. My name is Wanjiko Waithera, for the 9th petitioner. And taking off from where my senior Mr. Wamboi left off, I wish to submit on the issue that the respondents raised in their responses, that is separation of powers, in which they are seeking to have the applications dismissed on account that Parliament has the respondents, that is the Senate and the National Assembly, have privileges to conduct their proceedings, and such proceedings must not be challenged in court. And I wish for this court to be guided by the decision of Justice Lenaola in the Commission for Implementation of the Constitution versus the National Assembly of Kenya and 2 others, 2013 EKIR. And I will quote part of the passage where the court said that, to my mind, the separation of powers is not an absolute, to my mind, the separation of power principle contained in the Constitution is not absolute, and the courts, as defenders and protectors of the Constitution, have to be allowed to interfere where there is a violation or threat of violation of the Constitution. The court further went on to say that the primary duty of the court is to the Constitution and to the law, and which must apply impartially and without fear or favor or prejudice. The Constitution requires that the state to respect, protect, and promote and fulfill the Bill of Rights. My lords and my ladies, what is challenged before you are the proceedings that were undertaken at the Senate, and amongst what we are challenging is the right